Good morning. Thanks for joining us. I'm Jeff Nolan. I'm an attorney here in Burlington, Vermont at Dinsey Knapp McAndrew. I'm a member of the advisory board for the conference, so I'd like to welcome you all to Burlington a day after you got here, or hopefully a couple, and you got to enjoy the weekend. So we're going to talk this morning about the Campus SaVE Act, portions of it particularly relating to sexual violence as opposed to Clery compliance. There are some related aspects of that. But we thought that would be most relevant to you all. These sorts of issues are things that obviously we've all been focusing on a lot, many since before the Dear Colleague letter in April of 2011, but certainly with intensity afterwards, and then with the increase in enforcement actions, and now the change in the law, we're going to be focusing even more on the policies and more importantly, really, how you respond to these issues on your campuses. I'm doing a session tomorrow with the Human Relations Officer at Middlebury College, Sue Ritter, regarding deeper digging into response structures and the way that you go about responding to sexual violence on campus. But today we're going to focus on the requirements of the Campus SaVE Act and the educational programs and efforts that it's going to require folks to have on their campuses. And we really do hope to have a good interactive discussion. I think it's virtually guaranteed with Kim's lively personality. Maybe Kim, you want to introduce yourself?
I have a very lively personality, and I'm excited to present with Jeff. I think we're...
Okay, all righty, good. All right, so overview of requirements. I'm going to cover a lot of that. Policies and procedures as dictated by the law, we're going to talk about that as well. And then creating and implementing required education programs is what we're going to discuss. It used to be, when I did presentations on the Dear Colleague letter, I would start with this slide showing how simple Title IX is. Don't discriminate on the basis of sex in education programs. And then the irony was that when you look at the Dear Colleague letter and the pages and pages that come out of it and all the enforcement stuff around it, you would say, you'd start with this little kernel of don't discriminate on the basis of sex. Where do you get all of this panoply of effective requirements unless you want to be the one to challenge them in court? You know, people say, oh, the Dear Colleague letter, it's not positive law. It's just the agency saying that's the way they want to do it. But who wants to be the one to fight with OCR, potentially jeopardizing federal funding, et cetera? Virtually no one does that, and so far no one has done that since the Dear Colleague letter came out. But that was a bit of irony that we could draw on. That is no longer the case because the Violence Against Women Act has come to campus in the form of the Campus SaVE Act, which is, I don't think, a bad thing. There's a lot of really positive things that the Violence Against Women Act have done, and older versions of the law had congressional findings around that. There are reports to Congress that were done that track the success that the Violence Against Women Act has had and the amount of money that's been put out. But the law as passed in 1994 was focused on the criminal justice system. How can the criminal justice system better respond to victims of sexual violence, domestic violence, dating violence, stalking? That's what the law focused on and sought to train judges, sought to better build community partnerships, to better support people who were victims of domestic violence, sought to change the way that protective orders could be sought and how easily that could be done. That sort of thing. Training, National Domestic Violence Hotline, there's good information about heavily utilization of that. Unfortunately, with the shutdown, it's not getting used at the moment. Rape shield laws we're familiar with. You don't use evidence of a victim's prior sexual conduct against her or him in a court case. That sort of thing has become part of what we're used to in the general understanding of how sexual misconduct issues are dealt with in the criminal system. But these sorts of protections were not in the campus community by statute. The Campus SaVE Act was apparently designed to bring a lot of those sorts of protections into the campus system. I don't have personal knowledge of this, but if you Google background of the Campus SaVE Act, you'll see advocacy groups like the Clery Center Security on Campus talking about a link between the Yardley Love murder in in the spring and May of 2010. They'll talk about the Center for Professional Integrity, is that it? The 6-part series that was done talking about sexual violence response on campuses, a study and reporting series that was done in conjunction with NPR. And there'll be references to those when folks are talking about why the Campus SaVE Act came into being. Again, I can't vouch for it myself, but that is out there. It does appear, though, pretty clearly, that when you look at the Violence Against Women Act as it's traditionally existed, it has been imported into the campus context. And so now it is positive law, and we're not talking about OCR and maybe they're overreaching. This is Congress. There's no debate. We must do what is stated there. And to the extent that it incorporates parts of the Dear Colleague letter, we needn't debate it further. And when you're on your campuses, if anyone is reluctant about compliance and thinking that somehow it is less positive than a congressional act, well, this is a congressional act, so here we are. Effective March 2014, so certainly policies and so on, the work that you do on them should be underway very, very soon, if not right now. Okay. Bless you. Some of the definitions that the Violence Against Women Act have traditionally used: domestic violence, violence perpetrated by someone who's a spouse, who's a cohabiter, who's a parent of a victim's child, or similarly situated, and they define it as those kinds of relationships are defined under state law and also incorporate protections that would apply to people in a family or domestic relationship under state law. That's the basic definitions of domestic violence. This is not a Clery reporting compliance seminar, but I'll note that when they want you to record for Clery purposes, they want you to use federal definitions, not the state definitions. When they want you to create policies around this, they want you to use state definitions. Okay? So I'm going to say for most of the folks here, when you're drafting policy, be thoughtful of this and how state law defines it. So you want to work with counsel on defining that. Dating violence, violence committed by a person who is or has been in a social relationship of a romantic or intimate nature, and they look at these factors in determining whether that sort of a relationship is occurring, the length and type of relationship, and the frequency of interaction between persons involved. I've seen those factors routinely used. Kim, I don't know that I've seen bright lines being drawn anywhere saying, well, we're going to consider length and type, but this is the length that's enough to make it. I haven't seen that. So, yeah. Yeah. So I would, if you're trying to determine whether this is something that falls within a dating violence issue or something that maybe isn't sexual, so therefore maybe it gets treated through your regular conduct policies, not your sexual misconduct policy, my advice would probably be to be conservative, given that this law wants you to be applying greater procedural protections to victims of dating violence, and say it's dating violence. Okay? It doesn't mean you're more likely to find somebody responsible, but I'm saying if you're determining what process to use your Campus SaVE Act compliant process, because you're not going to have definitions and bright lines that tell you whether it fits in this. I think you make a reasonable determination that it's dating violence, you go with that, because you're always going to be better off providing more process than less. Okay? All right. Stalking, engaging in a course of conduct directed at a specific person that would cause a reasonable person to fear for his or her safety or the safety of others or suffer substantial emotional distress. Pretty broad definition. State laws often have definitions very much like this, and there's a federal definition as well. But this is your stalking definition. How many of you at this point have stalking policies already that weren't created because of this? So maybe a quarter. Okay. So as we talk about these things, obviously, when they're saying that you have to have procedures that make it clear what procedures are going to apply when you have a report of dating violence, domestic violence, or stalking, you now know you're going to have prohibitions of those things, okay, in specific terms. So in your student code of conduct and that sort of thing, you're going to want to be stating very deliberately, we prohibit stalking, we prohibit dating violence and domestic violence. Okay. And in terms of policies around them, I've seen more elaborate stalking policies, often drawn from state law definitions. I think probably absent best practices recommendations, which we'll talk about at the end of my portion, it's probably safe to go with the kind of language that you have here in defining what dating violence will mean for your campus at the outset when we hit May of 2014 and this stuff should all be in place. Questions so far? Okay. All right. So if you want to receive federal funds, which almost everyone does, you will have policies that comply with this. You will put in your annual security report the sorts of statements that we're going to talk about. Now, the requirement, because it's coming in through the Clery Act, really is looking at the annual security report and is not talking specifically about your student handbook. My practice has typically been to have the two be parallel with each other. And I almost think as you're working on policy development, you're going to want policies in place that are compliant with this. As of the spring of 2014, your annual security report's not going to be due until October. Do your policies first and then make sure your ASR is consistent. That's one way I would recommend going about triaging it. Yes?
Just correct me if I'm wrong, but aren't we going to have to take our stats, though, for annual? We should be covering, we should be taking note of our stats now.
That's correct.
Because it's good, we're going to be asked for 2013 when this comes into effect
That's
in
right.
2014.
That's right. So the stats question, again, I don't want to get too much into Clery counting numbers compliance. Not that it's not important, it's very important. But just to limit the scope a little bit, statistics, you should be doing it now because you are going to be asked for past stuff, no question. Yep. Make a good faith effort to collect what you can now. Yep. So some examples. Institutions program to prevent domestic violence, dating violence, sexual assault, or stalking. If you're having a statement of policy regarding that, it would sort of imply you're supposed to have programs that actually do these things, okay? So you know that you've seen this before in the context of sexual offenses, sexual violence, but the requirements of dating violence, domestic violence, and stalking are new additions given this law, okay? This language is similar to what's been there for quite some time. Procedures that you'll follow when there's an incident that's occurred that's reported to you that's within the range of these offenses. So that's got to be described as well. And again, when they're saying ASR, I'm reading ASR and your student handbook. Does that make sense to folks? Is that what you tend to do typically, is have them be parallel? A lot of folks are nodding. It's really awful on campuses when you have important policy statements that are inconsistent with each other. And I'm sure that's never happened on any of your campuses because you're here trying to comply as best you can. But it doesn't seem to matter whether it's a small campus, a huge campus, that issue happens. And so it's really important, I think, to really be careful about it. And frankly, given how complicated this can be, I'd just do it over again rather than try and cut and paste and we get every little thing. I'd do your student affairs thing, pull it over into your ASR, put it in the same place, and then maybe eliminate from the ASR those things that are specific to the student affairs procedure that you really don't need to have in this, if that makes sense, as a way of going about structuring the work that you do. Okay, policy statements have to provide notification about existing, I like the word existing that was put in there. It's not suggesting you have to create new things, but as far as existing programs that provide advocacy, counseling, health, mental health, victim advocacy, legal resources, that those should be there. I mean, you're used to that in the context of sexual violence programs that you identify for students, but this is new. And one thing I should have mentioned earlier, this applies to students and employees. Okay, so that's going to be something that you have to be thoughtful of when you're creating policies, is that it's going to have to apply to employees as well. And that may be very new for a lot of you, okay? Because typically we don't think of, this is grafting in many ways, dating violence, domestic violence, stalking onto existing sexual violence policies that institutions have created for students. And I know you have sexual harassment policies for your employees, but it's certainly not as common to have sexual violence policies with employees that are specifically sexual violence. They tend to be more sexual harassment, and if, God forbid, it gets to that level, we'll handle that as well. But this is being very explicit that it applies to students and employees, and the law often just generically uses the word victims, which is problematic for the respondents in these world. But in any event, that's how it's done, but it's going to apply to both. You were first, and then I'll get you. Go ahead.
When you're giving notification about the services, how comprehensive do you need to be? I mean, it's easy to list those on campus versus in the community.
I think you should make a good faith effort to work with folks who, on your campus, who make referrals often to community resources, to ask them, so there may be 5 or 6 top community resources, depending on the size of the community that you're in, that are really responsive to these issues. And so I'd make a real good effort. It's not that you have to be exhaustive. I think you have to talk with those who know on your campus about what are the best, most common resources that we go to. Yes?
Sorry, I just had are these materials going to be available?
This is posted, so it will be. It has been, I don't know if it.
Catherine was posting this
Yeah.
morning.
Catherine's sitting over in that room over there doing things. So yes, it will all be available. So you don't have to scribble this down.
Jeff, can I add to the response to the how many resources? I think something else that we've learned, whether it's and not in a compliance conversation, just in a student services conversation, is accessibility to those for the people that you're posting them for. So for example, when I was in Phoenix, we had such a plethora of community resources, 5th largest city in the nation, but then some of them in the immediate community were only accessible to people with a certain income level, or those without certain types of insurance, and others were too expensive for our students to go to. So we vetted that down to reasonable accommodations, but that were also actually accessible by the people we were promoting them to. Make sense?
Yeah. Yes.
So we already have those listing of helping resources as part of our current sexual misconduct policy. We've already started folding this into that policy. Do we need to add anything more than we already have?
I think what you should do is talk with the folks who have the most day-to-day experience with those resources and with the referral process, and go through whether the resources that you're currently listing are as robust as they should be in the areas of dating violence, domestic violence, and stalking. Particularly with stalking, it may be a little different. It may not be, but they may be there may be advocacy networks that are more legal in nature, for example, would help people get protective orders that deal with stalking. And the addition of, I think legal assistance was an addition. So you will look at the new list, talk to your advocates on campus and those who know, and say, are there other things that we could do? So I think there is a little bit of work to be done there. Yeah. Okay? All right. A bit on clery issues. Timely warnings must withhold the names of victims as confidential. Did anyone send out timely warnings and put the victim's name in it? There's a problem searching for a solution, searching for a problem, right? I mean, a lot of this makes good sense, but that one to me seemed a little over the top, but not a problem. We'll live with that. And you must also include in your ASR a statement of information about how the institution will protect the confidentiality of victims, et cetera. It seems to me that statement would be, we will protect the confidentiality of victims by not providing identifying information in our timely warnings. That's part of your timely warning statement. So we can get something done without any big controversy. That's good. You have to talk about possible sanctions or protective measures. So the idea that no contact orders, separation of people, as we'll talk in a minute about different residential and other accommodations. So you'd want to add that to your description of sanctions. And then obviously here the language rape and acquaintance rape stayed in there because it was using existing statutory language and then adding the other categories on the end of it. In other places, they didn't leave rape and acquaintance rape in there and just lumped it into sexual assault. You have to cover procedures to be followed, including, and you've seen this before in the sexual violence context, the importance of preserving evidence. I will say that probably more should be done, maybe along the lines of the gentleman's question. You've had a statement in there for years about put your clothes in a paper bag, not a plastic bag, don't shower, and all that sort of thing. I think it probably makes sense to speak with your local, maybe a special law enforcement unit that looks at these issues, and or your local prosecutor to say, okay, we have this new mandate, and I'm going to advocate generally you be speaking with those folks so they understand what you're now required to do in a lot of ways. We have a new mandate, and it should also, in addition to what we've traditionally said, have information about preserving evidence that might be important for obtaining a protective order in a stalking matter or a dating violence matter. And we want to learn from you as the professionals who will help get the protective order or be involved in that or prosecute these kinds of cases. What's important to you in terms of preserving evidence? Give us a paragraph or two so that we can provide that. I think that's a really good faith effort to do this, particularly in the absence of best practices advice, which the law contemplates, but we haven't seen it yet. And I'd be very surprised if we saw it before the law goes into effect in March. Questions about that? Okay. Information about to whom offenses should be reported. That's not controversial. Also cover the rights of victims to notify proper law enforcement authorities, including on campus or off campus. The option to be assisted by on-campus authorities if the person chooses to have assistance in contacting outside law enforcement. Or, and now this is more explicit than it used to be in the Higher Ed Act amendments, the right of victims of such offenses to decline to notify authorities. It used to say they have, the discussion of options. This is even more explicit. This you must talk with your local law enforcement and your prosecutor's office about. They've got to understand in the abstract, not in the middle of a media storm about an alleged incident, that you are now dealing with this mandate. That people that tell you that they have been the victim of conduct that would constitute a crime under one of these definitions has the option not to notify law enforcement. There's a bit of a tension there, I think, between your obligations to your students, to your general population, to keep the campus safe. You know that the OCR Dear Colleague letter talks about that you having a prerogative to do something in terms of investigation to keep your campus safe, even if the person doesn't want to support that. I think you can and must still do that, even if the person does not want to notify law enforcement. I see those as two different things. But as far as that person notifying law enforcement, that person obviously does not have to do it. Can you call law enforcement when they say they don't want to do it themselves? I think if you have a situation that you think warrants law enforcement intervention because of an ongoing safety risk on your campus, I think you can. How much that person chooses to cooperate is going to be up to the would-be complainant. Does that make sense to you? I think that's the only way to do it, because you still have, you wouldn't want to back away from that whole obligation and say, well, because it says this, we're just going to be hands-off. You can't do that. You've got to protect your campus as well. You'd have to read something like this relatively narrowly, I think. Questions about that? Okay. You'd also have to cover rights of victims and the institution's responsibilities around protective orders. To me, your responsibilities are, if you hand us a protective order, and maybe we've assisted you in making contact to get it, but if you hand one to us, and it says, we will keep the parties 500 yards apart, or that sort of thing, we'll do what we can to respect what it says. You can't independently create one. You can do your own no contact order, right? But the judicial part, your responsibility is to do do what the judge says. Procedures, prompt and fair and impartial investigation. Here's a big one for you. It's got to be done by people who are trained annually in issues related to the covered offenses. So there's obviously a very large training mandate. Kim's going to talk about that. Statement about the standard of evidence. As opposed to earlier versions of the law, it doesn't mandate that it's a preponderance. It just says what the evidence is must be, what the evidence standard is must be described, but we all know that in dealing with the OCR as a matter of enforcement policy, they're going to say it's got to be preponderance. So does anyone still fighting that battle? Does anyone? No, no one's doing clear and convincing anymore, despite the AAUP's desires. Yeah, I didn't think so. Advisor of your choice. So this language, like it, has been out there for sexual violence, but the new phrasing of it in positive law causes me some concern about what most of us do, which is say, you don't get to have a lawyer there unless you're being charged with a crime or you anticipate that you will be. When the lawyer is there, he or she is a potted plant and can't say anything. I think the potted plant part still applies, but because this language is in positive law and statute, and it says advisor of their choice, and it doesn't say advisor of their choice except if their choice is a lawyer, right? It just says advisor of their choice. I don't think you have to necessarily flag it in your policy and say you can bring your lawyer if you want, but I think you probably will want to say advisor of your choice as part of what you're saying. You know, you can have an advisor of your choice, and they're going to come along, and people are going to figure out, and they're going to say they want to have their lawyer there, and it could be the respondent as well, probably more likely, when the respondent has one. The complainant may want one. You don't have a right, you don't have an obligation to provide a lawyer to anybody, which is good. But I think it's more likely now that if somebody says, hey, I want my lawyer there, it's going to be hard to argue against this language and say that you can exclude that person. Make sense?
Yeah, I think where the dilemma comes in is when our codes have already predefined advisor capacity, and in our code it says not legal counsel.
Right.
And now the dilemma, which has not been answered, but I know it's been asked, is we've defined advisor as an institution. Do we just use that? Because this doesn't intimate attorneys. So we just say, yeah, sure, you can have an advisor. Does that? So I think that's where the lack of clarity will come in.
Oh, so you think we could try and argue?
Right. We've always allowed.
defined advisor.
Yes.
Among the people we've
Yes.
defined as advisors, you can choose the one you want?
Yes.
Good luck. I don't
People
know.
are looking to do that, right? But then I think where
Yeah.
the secondary dilemma comes in is when your institution has a protocol, not necessarily a policy, that if the accused student is represented by legal counsel, that they want legal counsel from your institution then brought into the conduct administrative process. I've only had the disfortune, should not offer an opinion on that probably. Sorry to the folks out in the multimedia world.
Yeah.
To only work at one institution that did that. Now what happens?
Yeah.
So now you have potentially a situation where you have the reporting party, i.e. victim, alleged victim's lawyer, the accused student's lawyer, and your institution's lawyer in your non-courtroom type process.
And to be as consistent as possible with how we normally do it, none of the lawyers get to talk to anybody but their own client. Otherwise, shut up.
Right.
Nothing from
So
you.
those are things I think when you mentioned earlier to not wait till you're in the heat of the battle of a high-profile media case, that those are tabletop exercises, if you so to speak, where you practice application. Because when people say, "Oh, we got this," we got this. We've already done our work with sexual assault. This really can't be that much different. We've got this. I think it is playing the devil's advocate, worst case scenario, and saying, so what will we do when there are 3 attorneys in the conduct meeting? Because we have yet to make a determination, and that allows us to be consistent, to have those conversations. So that's how I kind of think about everything Jeff puts out in the room for me as the lawyer, is okay, so now how does this really look on the campus?
Yeah. Well, you know, when I've defended a lot of cases that involve claims by complainants, and I've defended a lot of cases that involve claims by respondents, and they're filed on about a 50-50 basis, from what I can understand. When it comes down to process issues, I tend to say, give them the process. The substance is difficult enough not to have to deal with a claim that you blew it on process, you weren't expansive enough in the due process or the procedures that were given. Doesn't mean anybody wins or loses, but if something is, you can go either way on the way a process piece is read to say, should we give a little bit more process and maybe it'll take longer because the lawyer's going to be whispering in the ear of her client and blah, blah, blah. Okay, fine. But in the end, what's going to come out of it is they have one less argument, which is you kept my lawyer out even though Congress said advisor of my choice. I know you're so upset. I mean, I didn't make it up, but it's tough. I know. I mean, I've been saying to clients for years, you don't have to let them in. Even in public, right? Even in public institutions, you don't have to let the lawyer in. Maybe I'm wrong, and maybe it's worth fighting about, but I tend to think it's probably not worth fighting about because that language is unqualified. Unless something that Department of Ed comes out with as guidance on this in regulations backs off on that, and that would be a beautiful thing, and then things wouldn't change. But if they don't, and they just leave it the way it is, I'd be nervous about saying you can't bring your lawyer. Yes?
How does it look practically as a matter of scheduling? I mean, we email kids and say, I see your schedule, you have a hole in your day today between 1 and 4, I want you here at 1:30. How does this look practically? I mean, scheduling a deposition with 3 lawyers can sometimes take months to get everybody's calendars aligned. How does this?
I think they have to prioritize their calendars a little bit. Most lawyers have more than one person in their office, and you try and press it that way. But when it's, when I'm asked questions about scheduling, and I understand you've got a lot on your docket, right? But if somebody has a substantive reason why they say, look, I know you want me there in 3 hours, but I can't be there for 12 or 3 days or what have you, and there's no problem with an interim issue, that they're on campus and they shouldn't be or something like that, I feel like it's better to eliminate one of the arguments they were going to have and say, all right, you can have 2 more days to get the advisor of your choice there. Because then you can say, yes, you've got your scheduling prerogatives, you want to get things done quickly, but it gives them one less thing to argue about. Just having litigated a bunch of these cases, it becomes of epic importance to them, whether it really was or not at the time. Oh, it would have been so much better if you'd allowed me to have my advisor, blah, 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 whether it was a lawyer or not. I tend to say, all right, give them a little on the procedure stuff, because in the end, when you're dealing with the appeal, when you're dealing with a potential lawsuit, they've got one less thing to worry about, and then it's back to the substance. Were they responsible or were they not? And that's where your discretion and that of your conduct boards controls, as opposed to procedural stuff with courts feel perfectly happy to undermine the way you do it on procedure. They shouldn't second guess you on result. Yes?
I think what I remember from some of our older policies, not necessarily related to these particular cases, but any student appeals, we would try to write in real tight deadlines. You've got to write your policies with a little flexibility in your deadlines. Otherwise, someone's going to say, you bent the rule for this, for the complainant, but you didn't bend the rule for me as the defendant, or vice versa. And the apples and oranges, the rules that you're bending or not bending. So you might want to define where you have flexibility in your scheduling and how you accommodate how much room people have, so that you don't get locked in and feel you have to stick with it.
Yeah. Typically, folks
Yes or no?
don't say when they're going to schedule a hearing. I mean, they say we try to do this or that, but exigent circumstances and what have you. Yeah. Okay. Both parties simultaneously informed in writing of the outcome. Not a whole lot different than what we've been dealing with. I'll skip the FERPA note for time purposes. Appeals. This language suggests to me, the Campus SaVE Act suggests to me, unlike the Dear Colleague letter, which I read as saying, well, you can have appeal if you want. If you do, both parties have to have equal rights. I read this as suggesting you really have to have an appeal, because you're going to tell them about your procedures for appeals, which presumes you have procedures for appeals. I suppose it could be argued, but I don't see the point, and most people have appeals anyway. I mean, it gives you the opportunity to save a mess, so it's a good thing to have. Yes?
On your prior slide, the notice of both the victim and the accused. Is it the same notice? Do I send the victim the accused decision letter?
I don't
Or
think so.
I give her one of the outcomes. Just the same.
The question is whether the complainant gets the exact same decision letter as the respondent. I don't think it has to be.
Not violating FERPA if her letter says.
If it's So FERPA issues, if it's a sexual assault or something along this
Doesn't
this
apply.
line, it's not going to be a FERPA problem. Okay. If it's a sexual harassment, that's the piece I skipped. And it's lower level, then it's more limited what you can share. You can share, things that the person needs to know. Basically, is the person going to be on campus anymore? Is the person going to have a no contact order? Those are things that the complainant needs to know. So it's a lower threshold. Frankly, I might plan to share the same letter with both. I would probably prefer to do that, but if a school had a reason they felt like they couldn't, I could argue, this doesn't literally say that, but you'd have to read into it and say, well, it's implied that they'd be
We
the
had
same.
complaints when I did, and it's been a while, when I did conduct administration and we first started the process of notification of victims of sexual assault, rape. We had complaints that we never went to court. We resolved by handing over the decision letter where the victim felt that his or her rights had been violated because they weren't given the same exact language as the student found in violation. And those complaints actually came into the table with attorneys in my very limited experience with that. It didn't really vet out anywhere because we gave them the letter. So I think that it almost would be, why write a different letter? I think it's a
easier to do it.
CC on the bottom of who's been copied on it, and that lets them, it reminds them.
Well, and that allows you to do the simultaneous
Yeah.
piece. If you want to take that really literally, here's the email saying
Right.
attached.
Just a thought.
Yeah. You can see what that says. I don't want to take time out of Kim's piece. Anti-retaliation provisions, you wouldn't have done this anyway. There's guidance from this year from the OCR, Dear Colleague letter about retaliation provisions apply, and that is definitely true. Kim is going to talk about these requirements. I'll just flash it, and this will be posted. The last thing I'll talk about just briefly is that the law says there's going to be a best practices discussion going on between Department of Ed, Human Services, and DOJ, and that it's going to hopefully get out to you things that have been particularly successful on campuses given evidence-based measures. We'll see. I hope so. I do hope that the intent of this law is effected. I hope that it can better respond and help us respond to sexual violence and dating violence and stalking issues on campuses. It's obviously really important stuff. It makes it easier for you to advocate for it now that it's positive law, so that's my positive spin on this. Ann?
Refers to any schools that have updated their policies that you might suggest we have a look at?
The ones I am most aware of that I've personally worked on are in process, so I can't until they're out of process. But maybe at some point could post them to the website for the conference when things are done and they're vetted, and once they're public and published. When they're in the back and forth, the attorney-client privilege keeps me from doing that. Kim, do you have?
I would
in
just
mind?
look at all the schools that have survived a OCR visit. Honestly, that's who we've been looking to when I've been trying to help folks with this as an outside person, is starting with those individuals because they've been giving some thought to these extra requirements post the Dear Colleague letter. So that's a good place, I think, to start.
It's a start, but whether even
No one's, I think, stepped up and said, we have it done.
Yeah,
Anybody
off the
here?
top of my head, I don't even know that Missouri. I mean, Missouri's is out there, but I'm not sure theirs has been. Or Montana's at Missoula.
Okay.
I'm not sure that's been completely updated either.
I would just start
So
with those folks.
that's probably a place to look first at University of Montana at Missoula to see. Now, if they have sections in there about domestic violence, dating violence, et cetera, and then you look at the date, you may well be onto something there. Okay. All right. Well, I'm going to sit, and we got
Great.
questions afterward too.
Yeah,
Fine.
and throughout, just keep asking questions throughout. I'll move that over. My
There's the
little
power.
water bottle. How you doing? Good. I'm good. I'm glad you're here. I always like Colorado people because you guys take stuff to court. When I was on campus, I used to want to write thank you notes to say, thanks for not settling, because you gave us case law to pay attention to. So I appreciate that. Here's what I think is important, is that if you have moved on this and you have things that you are doing in response to Ann's question, we'll step back from the PowerPoint slides and you talk about that. Does anybody feel like their campus may be an institution that has moved on this enough that you would recommend to your colleagues here that they take a peek at your resources or your protocols or your procedures? People are like, who's putting their hand up for that, Kim? What a
Just for
silly
the benefit
question.
of the web, 75% of the room just raised their hand, so we don't have
Yes.
time to go through
Yeah,
that.
it's all the web people who are raising their hands.
Right.
Yeah, Mike Krenz, Texas A&M, I think he's out there raising their hands. Here's my role. Breathe, and let's prepare for compliance. It was if Peter Lake yesterday said to Jeff and I, why don't I set you guys up for your session, at least the second half? Because there were some really compelling statements that he made when he talked about facilitator university versus compliance university. So I appreciate Jeff's overview of the mechanics and the requirements of the Campus SaVE Act. And I want us to step back from that. Not that compliance is not a driver, but I want us to think about what we can do to ease our way into compliance with a focus on our students. I think how Professor Lake captured that yesterday, for those of you who were with us, was when he put his hand to his chest and did a gentle tap as he reminded us the work we do is work of love and care. And I think that it's interesting, if we step into it, we should start with what do we already have? Because I don't know that we're as lost as the initial perception was when the legislation was drafted. There's a lot of fire and anxiety and a lot of passion around these issues. And of course, when people are debating for legislation, we're hearing from young women who have not, in many cases, been treated well, who have had people who have retaliated in their experience and ostracized them or pushed them away for filing a complaint. We know that. We created an environment, when I say we, collectively, actors in higher education, that this legislation came forward. It's just what happened. We can't pretend that there was perfect processes and we knew exactly what we were doing. That's why we got dinged. So I think the first place to step, and this is not brain surgery, but I want you to think deeper about it. What's currently in place? Like who would be able to list already all the players that you know that currently are receiving reports on these topics? And just think about that. And how would you have that information? How would you know who's getting those reports? Right, but are you the only person who gets the reports?
Well, it's me, yeah, pretty much.
Because you're the compliance officer. Right. And how did you make sure your campus community knew that if a concern came to them from a student or an employee, that it had to find its way, Marilyn, to your place?
Well, we do a lot of, try to do a lot of training and trying to get the information out as to who gets what and why, and usually, I mean, everybody knows this. Everyone knows what I do to the point that wherever I walk in the room, they're all guys on goal, perhaps somebody's in trouble or something's happening. Because they know.
Marilyn is saying that when she walks, for our friends out in virtual world, that when she walks in the room as the compliance officer at Elgin Community College, people say, oh crap, we're in trouble. Marilyn's here. I'm sorry for that. You should parlay that into some gift or something annually, a day for compliance officers. We can make t-shirts and buttons and have a Twitter hashtag. It would be awesome. Here's the thing I want you to think about, though, is how do you know who to train? How do you know who to tell what to do with the information? We make very shallow assumptions sometimes with those concerns, and this is sitting with attorneys and practitioners and administrators in preparation to meet with you all today and saying, what are the challenges that you're concerned about? That's where my information came into this. And they said, I don't think we realize, I think we shallowly train people on what to do with the report because we assume that those reports only go to certain players or certain offices, particularly those that we direct on our web for them to go to. But here's a weird little piece of data. We know by research, not by anecdote, that one of the last places students will go to report violent or high-risk behavior, even if they're a victim, are university administrators next to clergy and law enforcement. So who are they talking to? So you see how we can't get caught up in the bright white line of check the box of the legislation if we really want to meet the objectives of the purpose of the law. That was such a powerful statement that Professor Lake made, and I know it wasn't something that we would attribute only to him. What was the intent? We've done that with Cleary in these rooms. We've done that with the Title IX legislation to get the spirit of the law. So it's thinking about first is who's receiving these reports, and then what systems do we already have in place to support those people. It says in legislation, right, Jeff, that we have to make room for the reporting party / victim. And I'm sorry, I'm using reporting party / victim not to be disparaging, but at this juncture in the process, they're yet to be fully identified in a university process as a victim, and it's a carryover of my conduct brain. Okay, so the person who believes that they've been victimized and potentially have been. Don't want to disparage that.
I think that's right, Kim, and I think it's important that even though the law says victim as a generic, let's just say student and employee together, you don't put victim all over your policies in your judicial affairs context. Whether you do in your ASR or not is a little more debatable. Probably a lot of people will, but frankly, I'd rather put complainant in there.
Right. And it's difficult to manage that, particularly when you think of all the players, when the advocacy office is supporting this initiative, and the conduct office is involved, and legal counsel's involved, and police officials, and then residential life administrators, just a plethora of people. There's a lot of personal feeling on that, but I think it would be more legally sound, and I appreciate you supporting that.
The respondents' parents are just as fired up as anybody,
Yes.
so I wouldn't put victim in your policy.
So I would think about when the legislation says you have to make those accommodations for classroom moving in a classroom, residential life reassignment, any number of things. I remember, and again, I don't pretend to have practiced on campus yesterday, but it wasn't that long ago. I can remember working on a new urban campus, we had one dining hall. And we had it was an identified victim accommodation where the question became, when can he eat in the dining hall? He didn't live in the residence hall anymore, but could we deny him the privilege that was the place he was gonna eat? Do you see what I'm going with this? I don't need to over-explain that. So what systems, before you step into change, what's already in place to meet that obligation? What systems are in place to provide class exchanges, relocation in your residential community, and what's the process for that? Because I know some of us, is anybody here from the wonderful world of residential life? The Cirque du Soleil, as named yesterday, it was one of my favorite lines of the conference. So when you think about that, people will assume that can happen in a matter of hours, and sometimes it's much more complex. Can you?
On our campus, we have a housing branch, we had to physically relocate the respondent to an off-campus hotel because we don't have extra beds.
Sometimes there may not be that extra bed, and so understanding the process, I think this review time, Jeff, for us, pre to March 2014, is as much to step back and do an audit of sorts and say, well, it takes a little while to do that, or we're short beds, and what would our secondary option be of relocation? Do we have a relationship in the community that's reasonable? Because what if we offer to this person to relocate to a hotel that is not within walking distance, and they opted out of a vehicle because they were living on campus, and now we've created an environment for them that is more stressful, and oh my gosh, I've already been victimized, why aren't you taking care of me? Yeah.
But aren't you almost potentially in violation of Title IX because you're re-victimizing the victim by making them move instead of the other person?
The legislation does not require us. It's to accommodate the reporting party, the victim. And that would be in best practice with conduct, because if we tell an accused person that they have to relocate, then we will find ourselves in court with an allegation that we presumed guilt before a conduct meeting. The legislation says we have to make accommodations for the victim, which does not imply to me, based on prior best practice, that we move the accused. And I'm ready, I'm good with talking about that, yeah.
How temporary can they?
I don't know, it depends.
Kim, the reason I bring that up is because we have a sexual harassment case that Equal Opportunity and our conduct office in terms of reading Title IX said that if we try to move the complainant Because, I mean, they're both in the same class. And so we were going to see what was the other option of class to move her, and it was decided that that would be viewed as a re-victimization of her rather than moving him to the other class. So
And
the
I've
reason I
been-
asked that question
I've-
is because
right,
it's the same with the
right.
resident's life.
And I think that you may have to look to your community. I don't know where Jeff would advise on that, but I was just with the community working through an issue where legal counsel, equal opportunity office said the opposite, because they didn't want to label someone as having been found in violation and automatically determined to have been a perpetrator when they hadn't had due process yet.
Yeah.
Short-term remedy
Right.
until the process.
Right, so I think that that
is
could
make a
be
determination.
fast and hard in the law. What would you say?
I typically go with moving the respondent because you get into retaliation claims otherwise, and it's very hard. If you have someone who literally signs off as a complainant on her being moved, to be stereotypical, then I'm okay with that if it seems like that would really be holistically the very best thing. But if you have the hypothetical of they both want to stay where they are, they both want to stay in the class, typically you move the respondent because you get into retaliation stuff otherwise. And I don't think the respondent is going to have a claim given this mandate, although I've seen them, and our office defended one that went to the Second Circuit where one of the guy's claims was, you made me not take the class, but that was a case where he was found not responsible, and then the class was subsequent. I mean, we won the case ultimately, but
So I think
That's
it's
typically where I
working
go
with
with it.
counsel because it doesn't
it's
say
very
you
low.
have to move the
No,
respondent.
you're right on the law. It does not
Doesn't say that. It says we have to make an accommodation for the victim.
But the real tough part is that it says, under the Cleary side of it, as it always has, you make changes in accommodations based on allegations, not findings. So it's hard.
So I
It's really
think,
hard.
but I think that the key here is, first of all, law conference disclaimer, and I want to zip through because we're short on time, is that legal advice at the law conference is specific to clients that the attorney advises. Jeff is always great about that. If you don't have an attorney to seek counsel from, start with Jeff's advice. He's the lawyer. But you should always work within the confines when it's a legal question of the legal veracity of your own community. Because some may err on one side and some may err on the other. And when you make that decision, you have to know that you have their support.
Absolutely.
So I've had just different experience. Not better, not worse, just different in similar situations.
And you're right on the law. It doesn't specify.
But I think it's also stepping into, one of the things we have to do is make sure that we're training investigators, right? So who currently would investigate and what does that look like? And is it a pool of people that is appropriate and deep enough to be the investigators? Because is it really enough to just have one investigator who serves in the multiple capacities? So you have to think about who are we working with and then who resolves investigations. I love the term, we talked about this, resolve. Once the case is incident or the complaint is resolved, what does that mean? I assume it means adjudicated, but it doesn't necessarily mean adjudicated. And I don't know, have you had your session yet? Is that tomorrow?
We're going to talk about Middlebury does.
Tomorrow,
This is a little
Middlebury is
different.
going to offer a really interesting method of resolution that it looks very different than adjudication. So it's interesting, but who currently resolves investigative reports? And I think you have to identify all those players before you can really prepare yourself for the March compliance 2014, or we don't know who we're working with. And here's a really compelling question that you brought into the room already. What services are currently in place for reported victims of crimes related to or incidents related to these topics? We need to know what resources exist. Because just because there's a rape crisis center in your community does not mean that they're prepared to take on clientele that are not rape victims. They may be so overworked and extended with rape victims in a community that if we start to tap them to be the advocates and the support for stalking victims and victims of other types of violence, they may say, we're at capacity and we have to prioritize. And so what are those true resources that are available both on your campus and in your community that are accessible to students? The reason I put that at the bottom and bolded it is because I think that that's where that's the purpose. Of all, we need to investigate, we need to adjudicate, we need to do the right things, but we also need to make sure there's support in place and that we're properly supporting these individuals. And we can get lost in process and procedure and forget about service, the student service piece. A few just FYIs, and I would highly suggest that if you are not the conduct officer from your community, that your conduct officer be someone that you speak with before you start to make change from a compliance officer's perspective or a legal office perspective. If you're looking for best practice, you're exactly right. Department of Education and the Department of Health and Human Services are supposed to be our resources.
And DOJ.
And the Department of Justice for best practice. We'll wait and see when that comes to us. But there are best practices that I think we can refer to already. Some of the resources that are going up, I just emailed Catherine and said, when will those be up? Is a resource list of where you can find best practice. But in the, when you're looking
Kim,
at...
it's obvious, it's a good guess that
Yeah.
when they come up with it, they're going to draw from existing stuff.
Yeah.
So if you go to the Office on Violence Against Women's website and you go over to, it's not easy to find, it's like areas of focus.
Right.
Click on areas
That's
of
on
focus.
and we have that on our resource
you've got it all
sheet.
in
That's
the
all
thing.
posted on the web.
And then there's a million
Right.
links there, and there's trainings and
Yeah.
videos, and there's a lot of stuff. They're going to draw from that
Yeah.
stuff.
But as you redraft language in your code, remember the best practice that already existed in the field. Because I really did, listening to Professor Lake, and I know many of us have done a lot of thinking about the driving of compliance. And we're fortunate that we have people like Marilyn who will serve in those roles as compliance officers and take that on for us. But we also already have spent a lot of time and energy and courtroom time and professional development and research time developing best standards and best practices. And I don't want us to abandon those in the rush to be compliant. And so we have to be cautious when we write our definitions to use either state language or federal language, but then what did John Lowry and Ed Stoner tell us in the Model Code of Student Conduct? And you know what they tell us. They say, be cautious of mirroring the law verbatim. Reference the law, but be cautious of your code mirroring the law verbatim for a lot of variant reasons. And so one of the resources that we've put out on the site, actually under Public Institution Affinity Group, is just a reminder, the most current copy of the Model Code of Student Conduct, the most current recommendation from the Field of Conduct Administrators Professional Association to think about. Because we don't want to be, we need to be aware of the multiple hats. You might be the community that's adding investigators as a result of these legislative compliance pushes. You might be part of a community that historically your process was really simple, and a complaint came in and it went to the conduct office and the conduct person reviewed it, and maybe they did a little investigation, and maybe they wrote a charge letter and they ran a little hearing and they administered a little sanction, and it worked well. But this becomes much more complex. So now we have to think about what else have we been told. We have federal mandates, but we also have best practice by court voice. And while Professor Lake tells us that the voice of compliance might drive our work more than the voice of the courts, I'm not ready to abandon the voice of the courts. I'm not ready to give up on them. And they say, be cautious of the multiple hats. What does that mean? That means don't investigate, adjudicate, et cetera, et cetera. How do you play the role of the person that's providing the support to the victim when they go to report to the police official? Because we say we need to give them support. We're also going to be and then we investigate the alleged incident and turn a report over to someone else who adjudicates. I would tell you those things have been tested in court, and we have consistently seen. I kept trying to find the case from the Fifth Circuit. There was a case that went relatively far through the Fifth Circuit involving Texas A&M University, and it was the Parsons Mounted Cavalry case. If I haven't been able to, I don't know why, I'm not searching properly for it, but I'm going to keep looking for it, but you may seek that out because it speaks to this as well, specific to investigators and adjudicators. And beware of undefined investigative procedures. It's not enough to define the process for the student or the employees, because remember, the legislation, Jeff, I think doesn't just say students, right? We're supposed to be employees as well. Oh my gosh, what? Employees as well? So now have we even thought about employees? And how would we make a reasonable accommodation in the office space for the employee? What does that look like? And who would make that determination? Probably already defined for us somewhere, but shouldn't we maybe check in and say, make sure that individual knows we have legislation that may push that expectation outside of the realm where they've ever had to consider it?
Yeah, I mean, it just says changes in working conditions.
Right. So what does that look like?
Arrangements,
And what have
situations.
we done in the past, and what do we have the capacity to do? And who would make that decision? Again, not in the middle of a heated debate with media attention and the fear of the compliance people circling us, but really just thoughtful consideration outside of name, office, personnel, no personality. Let's just like hypothetically play through this and figure out the answers to these questions. That's what we have from now until March to be doing that. Dr. Brent Patterson, Associate Vice President at Illinois State University, has done some great work in investigative procedures, and his work, informed by the work of Ed Stoner, legal litigator and legal investigator for colleges and universities, has been identified in the field of professional standards as a best practice by the Conduct Administration Association, the trade field. So when we look to what Dr. Patterson says in the context of investigations, make sure those things are defined. What does that look like? And not just training on procedure of investigation, but have we published that somewhere? Because I think this victim has, or this reporting party has a right to know that too. Beware, follow your process. I think when in doubt, follow your process. And as we step back through what's currently in place, the best advice and things that folks are already working on is asking these questions and thinking through who's providing training, who are the training facilitators on incidents, on what to do to gather facts of incidents. Is it Residence Life training RAs? You take a report, here's what you should do. Have you ever thought about that? How closely are we working with Residential Life staff who may be doing their own informal inquiry? A student comes, initiates a concern about stalking, relationship violence. Maybe it's not even about them, maybe it's about their friend. We do our resident assistant training. We changed the names of resident assistants. I was just somewhere, they're calling them resident monitors at the University of South Carolina, whatever we're calling them. The young men and women who live in the hall. How are we educating them? And if we don't want them to do inquiry, how many times have we said that? It's not your job to do an investigation, and yet they feel compelled in a supporter role to do the investigation. So how are we educating those individuals about incident inquiry and investigation and resolution? Because the law says we have to train on that, but it also says that we not just have to train on incidents to those people, individuals investigating or resolving these cases, types of incidents, need to be trained on the issues. And that was a little word that was kind of in there that I'm not sure those that wrote the legislation even thought about. Issue, incident mean very different things to me. Because how I'm going to process an incident is one thing. What do I need to know about the issue of stalking? What do I need to know about the issue of of relationship violence? What does that really look like? I'll tell you, when I started out as a young conduct officer, before anybody legislated or mandated, or we had guidance and we had court cases and we had some best practices. I was fortunate enough to work under some of the men and women who had actually helped define that field. I would go to training at the Rape Crisis Center in the county where I worked. There was a 40-hour training if you wanted to volunteer at the Rape Crisis Center. I went to training. My volunteer give back for the free training was then I did a training on how to tell people how to access the university conduct process. And I did that so I could have some understanding of victimology. Not so I could become a victim's advocate, but as a conduct person, I wanted to understand the issue of sexual violence and rape. So I'm like, how do I do that? Well, I read and I study, so I went to training. What does issue training look like? Because they were very specific with that language. And again, you don't have to say, oh my gosh, Kim, now I have to write issue training. No, we have that. See, that's the thing. Don't you agree? I mean, you've been working with this in Middlebury. There are best practices predefined. The resource page up on the web. If it's not there, we apologize. I said at the opening, we're always late posters, but what we post is usable. There are best practices and what that should look like and where you find that information. And then who's responsible for the education and awareness campaigns? Do you have a prevention specialist? Is it not really anybody? I was just with the community and they said, we don't do leadership anymore. Leadership is everybody's job. Sometimes I worry we don't do alcohol ed anymore. It's kind of everybody's job. Yeah, right. You know what happens when it's everybody's job? I don't know. I grew up with 5 older brothers. Everybody's job at my house meant nobody did it, and we'd go, well, I thought he did it. I don't know. What's the deal? Like, we know that doesn't work. So who is responsible for that, and have you engaged them? And here's the key thing. This legislation told us it was about prevention, and prevention is about a process, not a program. And probably the key thing the prevention specialists tell us we should know rolling into March 2014 is we can't hand this problem to one person, because prevention is about shared problem solving of a community. So we can't hand the problem of sexual violence to the Women's Center. We can't hand the problem of sexual violence to the Sexual Violence Center, whatever the term is, because the legislation is saying campus community get involved. So we have to think very broadly, and if you don't think that's what it's saying, well, look at how many people we're supposed to train and educate. There is a framework. How do you put together a prevention, education, and awareness programs? If you don't have that person, well, they might have closed the higher ed center, but there are those of us who pilfered the resources when we got the first memo before the webpage went down. And so Linda Langford and Bill DeYoung wrote a prevention framework that in the best practices of sexual violence prevention work is referenced. The environmental management socio-ecological model, the purple book, will be up on the web for you to use. We can't get hard copies of it anymore, but we have it for you. And it tells you how to write violence prevention, education, training, policies, and it's a best practice. It's a comprehensive overview of how to make that happen. You have prevention people on your campus, they know this process. And they've gone as far as to tell us these, if you're doing an audit of what you're currently doing, if you're stepping back and saying, we have a great educational curriculum on dating violence. We have wonderful work with stalking. We have this topic. I was just at a small private school in the Southeast. They bring in a theater performance troupe to all their new students, and they do theatrical performances on these issues during new student orientation. Interestingly enough, sitting in a conversation with students, they said that the theater troupe was too entertaining and it kind of made this seem funny, and they were offended. Oh my gosh, everybody on TV, there's a bug in my water, and my friend just saved me from it. Thank you very much.
I'll get you some
that's okay.
water out of a different bucket.
I think that's important to, that's what I love about us, Jess. We can just talk about anything. I'm on the mic, I'm on the movie camera, we're great. But I think this is what you should be looking for, thanks Jeff, when you're evaluating your programs, is are they aligned with what we would call the principles of best practice in prevention? Well, how do you know that? If we didn't do a whole session on that at Vermont Law, because this is documented for you. These procedures, this context is already designed, and there's great stuff that we've actually put on on our resource page of how to do an audit of your educational, what metrics you should look for in your education and training. I would recommend that if you are kind of at a place where you get to start fresh with that, or you want to start fresh with what you're doing for awareness and education, you look at the work that was done by Michael Klitzner in regards to environmental change. This actually comes from a program he did on meth, which is very different, but the concepts of high-risk behavior and how to make environmental change or community culture shift. And probably these are the key things that he tells us we should be trying to do. If this is really about reducing incidents of stalking and acquaintance rape and dating violence and sexual assault and domestic violence and all of those things, then let's not become so compliant driven that we forget that this could be an amazing opportunity for us to open some doors on campus and re-examine how we're doing our work. Because as Klitzner says, set the context, make your community standards clear. The legislation says we have to do that, right? Mm-hmm. It says we have to make our community standards clear. How have you told your community that stalking, date rape, domestic violence, and rape are not welcome on your campus? Certainly, I hope in a more positive way than don't rape, right? I mean, I'm trying to think of what that button says because we do too many buttons. What is that messaging? How have you used civility and respect and things that we know, not just from the Kumbaya student affairs perspective, but from research into education on high-risk behaviors and sexual violence are more likely to engage people? How have you communicated those standards? Because the legislation says we have to. And really, what the legislation says we have to do is we have to give a very clear statement that we prohibit those acts. And we define them, and we also have to do education on bystander intervention. Last year, Indiana University, Leslie Fasone, soon-to-be Dr. Leslie Fasone, came to the conference. On the 2012 website for the law conference, it's still posted. And I know you're probably just annoyed that I'm saying this to you, but on the resource page that Jeff and I put up this morning, there's the link and the password to get to those resources on a good bystander, how to create that. And the University of New Hampshire has done some great stuff in that area. Again, it exists. You don't have to wait for the Department of Education.
I think UNH's stuff was cited by the Vice President in rolling out the
Yes.
Campus SaVE Act.
Yes. And so, and they're very willing to share. So I think the interesting thing is that in the capacity of meeting these objectives of the legislation, these mandates in the legislation, we're being given a chance to set a very clear message to our community about what we expect. That can be pretty exciting. That doesn't have to feel so heavy and compliance driven. It can feel more positive. My advice, and I just put a quote on the slide from our colleague and friend, Dr. Gary Margolis. Gary's very passionate about sexual violence education, and he's done some great stuff in that area, and he's a strong advocate and a strong voice for men to become engaged as well. But just remember, we can't play the game of we're doing this because the legislators told us we had to, and we can't step backwards into old school education of victim blaming. The legislation really the compliance language really kind of freaked me out when it said that under risk and harm reduction strategies, we needed to, one of the references made was that we needed to teach people how to fend off attackers. I just don't want people to think if they just put in a self-defense course, they've met the spirit of this. Because that's kind of a tertiary risk management response. I think we would like to have primary and secondary risk mitigators, not wait for the moment of attack. So I think that's critical. Here's the spirit of the law. This was the intent, to generate transparency. That's why we have to report our incidents and tell our students clearly and our employees clearly what their options are. Accountability, we have to report our incidents. And we have to put in writing what we're doing from a prevention perspective. We can't just say, we have a prevention program. They want to know what it looks like and who's involved in it and how it's rolled out. We need to give specificity. The spirit of the law says that we need to be, this is supposed to be about education. One thing that we know from the work in high-risk behaviors and sexual violence research is knowledge alone doesn't change behavior. So education, the spirit of the law is to use best practice in education. So it's not enough to say, check the box, we have a program where we read to students where to go to report incidents and what we'll do for them. And I love the fourth spirit. I like to kind of play with that one a little bit. They said the other intent was collaboration, and that was supposed to be between y'all and the Department of Ed and the other federal departments. I would say let's make the spirit of the law that we open up more collaboration on our campuses and that we think intentionally about this is not the problem of the compliance officer. There are a lot of different people who play into this legislative initiative, and that's where I think the spirit of collaboration needs to be given full consideration. I don't know what's going to happen between now and March. All I know is that we're going to be talking about it, and there's already a lot of great resources out there. Jeff, I don't know if there's anything for the good of the order you'd want to put in the room.
All I would say for the good of the order is that the compliance stuff and getting your policies straight is the easy part. It's a lot of busy work to be done, and you've got to get it done right, and it's got to be precise. But the hard part is working to prevent the occurrence of these incidents to the best of your ability. Because if you don't, as we all know, it is tragic for complainants, for respondents, for the institution. Even if you've complied in every possible way, incidents are tragic, lawsuits about them are tragic. There is likely to be filed by one side or the other. If being forced, quote unquote, to do compliance and a better job at education is where we are, embrace it rather than fight it. It's Congress, it's not OCR. We got to do it. And if we can prevent some of these, we're all better off. Absolutely.
Yeah, and again, I want to say that let's not be the besieged Klan that they wrote about, that Thomas Jefferson referenced when he talked about the spirit of insubordination with the behavior of our students on college campuses centuries ago. That was the impetus for the development of the field of student conduct. If you read the history of that association, you'll find the language of the besieged Klan. Let's not be that. Let's find the openings in this opportunity to do our work better and to maintain that high level of commitment that we have to care. I think that's probably the key thing. Questions, concerns? This clock is actually a little fast. I'm going by Apple's time. Questions, concerns? Yes, ma'am.
Quick question. If a student comes and shares allegation of stalking or domestic violence, but the respondent is not connected to the university at all, I'm assuming that under the new law, you still have to provide them with victim services, but you're not going to investigate. You don't have any jurisdiction over somebody who has no connection to the school. So
Jeff, I'm going to say the question for the folks on the video real quick. Report comes in, the alleged perpetrator is not a student or an employee of the university. What do we do?
I would recommend and provide the services. Whether you have to or not, when you don't have any jurisdiction over the respondent, I'd say you probably don't have to, because so much of this is focused on disciplinary process, and you don't have an ability to do that. But I certainly would, I would provide the services that are available, the referrals and that sort of thing, and I would also make sure that they have the connections to resources and so on. And I would help with the law enforcement referral, the kind of assistance you provide if it wasn't on campus. Whether you have to or not, I just think you're doing a good service for your students that way. And when we think about this in threat assessment terms, for example, you're always cautious about domestic violence, dating violence, spilling onto your campus. So if you're involved at some level and you let your threat assessment team get involved with information you might get through that, you're keeping your campus safer, not just for that person who's reporting to you, but for everybody.
And I've worked with police officials who in that capacity, that's been our entry point has been, here are resources for you as an employee. It was an employee situation. But then we had the ability to do some work with the campus police and ended up actually putting the campus on alert that if you see this person, you need to call immediately because it became a high-level threat. Yeah. But that reminded me, when we do our evaluation of what we're currently doing, it's not just student on student. It's how is this handled, what are we doing with student who makes an allegation of an employee, faculty, staff, other, employee with a concern about the behavior of a student, or employee. Yeah. So there's a lot of different systems. I think we get really caught up in student. And this legislation is really clear that that's not the case.
Students and employees are protected.
Right. So all the combinations thereof of students and employees.
But again, you think about compliance versus doing what you most want to do, and what you want to do is keep your campus safe.
Right.
If you just focus on compliance and say, well, it doesn't say we have to learn anything about this domestic issue that's going on. Well, for your threat assessment team, they're going to want to gather information about that, or they should, right? Because it could be a lot broader. You had a question?
It's still, you do have to do more if it's someone you contractually have at one of your contracted sites or something like that, right?
Yeah, if it's somebody you've got some kind of relationship with, then you would definitely want to do something.
Yeah, Jeff, I love what you just said about the threat assessment team. That's the other thing. Don't become so focused on this one systemic thing that you forget. That just because it doesn't say you don't have to doesn't mean that your threat assessment team shouldn't keep doing what they're doing. Right. Don't you think sometimes we get so focused that we're like, oh, you shouldn't do that? Well, it doesn't say we shouldn't.
Well,
This is good. We're gonna
if you
keep
push
doing
the
that.
complainant away and say, hey, it's
Yeah.
not our problem,
Right.
he's not within our jurisdiction,
Then
you're
we're
not
really
going to get the
not-
information your team needs.
Right, great. Other questions, concerns? We appreciate the chance to
Yeah,
just
sure do.
spend a little time on a very complex subject. A lot of great resources out there. Jeff and I are both available to provide follow-up information or resource if we can. And of course, everyone in the room is a resource as well. Enjoy the rest of the conference.
And tomorrow we're talking about similar issues, but not SaVE Act specifically. So thank you guys. Thank you, Kim.